All right, good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Courtney Atwood. Courtney Atwood. I have a note that she's at some kind of center for addiction. We'll recall that case. Misty Backus. Robert Burke.
Present.
Tammy Cocaine. Tammy Crocker. Noemi Esquivel. Jesus Landa. Luis Leja. Lena Price. Keith Pryor. Keith Pryor. Oh, Polk County, Florida still.
Yes, sir.
All right, I'll recall that case. Who's our lawyer on that case? Anyone? Ms. Abraham?
Yes, sir.
Jeremy Snelson. Here, right here. Jeremy Snelson. Jeremy Lynn Snelson. That's a sanctions court hearing. Alexis Stevens. Alexis Shay Stevens. Keith Thomas. Ian Gray.
Present, counsel, Your Honor.
Thank you, Mr. Rumble. James Godwin. I believe Mr. Godwin's going to be appearing via Zoom.
That's right.
Bennett Watts. Damon Watson.
Here.
Drake Andrews. Roderick Bradley. Roderick Morrell Bradley. Donald Ellis.
Here.
Jeremy Estridge.
Here.
Jay Harrison. Fernando Hernandez.
Here.
Jeremiah Holmes. Leola Jackson. Adriana Jacobs. Have a note that she's heading to the emergency room for a broken wrist or something. So I'll recall that. Braxton Johnson.
Be appearing.
Okay, yes, he just entered. Kathy Leha. Amanda Reyes. Sean Schnack. Haley Smith Arndt. Jeffrey Neal Walker. Mark Lemon. Brandon McClanahan.
Your Honor, that's supposed to be a plea of, just playing against everyone, so I don't know.
Okay. Delvin Mitchell. Tu Nguyen. Jeffrey Smith.
Here.
Jamie Warren.
Here.
And Justin Williams. All right, is there anyone whose name's not been called? All right, counsel, we have anyone that's ready? Mr. Rumlow, you ready?
I want to go first, Your Honor. May we approach?
Yes, Ian Perry Gray, if you'll come forward, please, to the podium. All right, and cause number CR 24-99, State versus Ian Perry Gray. Court finds that there's an agreement between the state and the defense to continue the pretrial hearing to January 7th, 2025 at 9 a.m. so that the defense can get a new defense expert. Court grants that request and sets pretrial January 7th at 9 a.m. You're free to go.
Thank you, Your Honor.
Thank you, Ms. Marlowe. Any other counsel ready? Mr. Hawkins? You ready, Mr. Godwin?
Yes, Your Honor.
Excuse Your Honor.
Yes, ma'am. All right, this is, oh, you can go ahead and unmute, Mr. Godwin. This is cause number CR 23-140, CR 23-141, State of Texas versus James Wesley Godwin. For docket call in each case, court is noting that Mr. Godwin is appearing via Zoom today with the court's permission. Any announcements, Mr. Hawkins?
Your Honor, we're asking again for a pass due to Mr. Godwin's condition. He had another surgery just recently and he's recovering from that. And so I've not had much contact with him because of his condition.
How long are you asking for?
Judge, just next docket, and hopefully between now and then, hopefully he'll be at least able to be up and around.
All right, Mr. Godwin, I'm going to reset both of your cases to December 17th. That is a Tuesday at 9 a.m. You
Thank you,
understand?
sir.
All right, you're
Yeah.
welcome. You're free to go.
Thank you.
You're welcome.
Thank you, Your Honor. And that's all I have today. May I be?
Yes, thank you, Mr. Hawkins.
Thank you, Judge.
Yep, that's what they're saying. Okay.
All right, cause numbers CR 24-196, CR 24-197, set for arraignment, Courtney Joe Atwood. Court finds that it has received notification that Ms. Atwood is in some kind of alcohol addiction recovery and is set to discharge December 12th. Court will reset her arraignment for December 17th at 9 a.m. in each case. Mr. Schmidt, are you still working or do you need
I'll
time?
be ready in 1 minute. I'm gonna grab a guy and bring back.
Okay. Morning.
You understand what out there and talk.
Yes, sir.
So go deal with Mr. Webb. Maybe I'll be back out in Mr. Webb.
All right, Mr. Schmidt, who are you ready on?
This is Jesus Landa.
All right, this is cause number CR 24-213, State versus Jesus Landa Junior for arraignment. Court has found Mr. Landa to be indigent for purposes of Sixth Amendment right to counsel. The court has appointed Honorable Richard Schmidt as attorney. Mr. Schmidt, are you ready for arraignment?
We are, Judge.
Go ahead.
We received a copy of the indictment. His name spelled correctly, understands the charges and the range of punishment. We'll waive formal reading, enter plea not guilty, ask for a pretrial setting.
All right, court finds that Mr. Landa, having waived the formal requirements of arraignment, court does enter his plea of guilty, not guilty into the record. The court sets Mr. Landa for pretrial hearing. Do you want that December 17th, Mr. Schmidt?
Sure.
Court sets Mr. Landa for pretrial December 17th at 9 a.m. And Mr. Schmidt, if you'll make sure that Mr. Landa meets with Mr. West to sign his conditions of pretrial release.
Yes, sir. He's doing that now.
Okay.
Just hang loose, maybe I'll go back to Mr. West. Drake Andrews.
Mr. Andrews, if you'll come forward, sir. This is cause number CR 24-89, State versus Drake Allen Andrews for docket call. Go ahead, Mr. Schmidt.
Judge, we're gonna ask for a final docket call, Mr. Andrews. I think about the case officer. With some additional evidence, I don't know if they had an opportunity to do that.
I'm not aware of it, Your Honor. I'm sure when Mr. Hartwell received it, he had a rather last minute thing come up this morning, so we had no objection to a final docket call.
All right, court sets Mr. Andrews for final docket call on December 17th at 9 a.m. Mr. Andrews, I show that you may be delinquent on your pretrial release fees. Have you paid those recently?
Friday, when I get paid, I'm gonna go up there and pay them.
You're going to pay them this Friday?
Yes, sir.
All right, I show that you're delinquent about $90.
Yes, sir.
You'll be able to pay all those in full?
Yes, sir.
Okay, all right, I'm gonna make that note. All right, once he signs, he's free to go.
See what's going on. Jeremy Estridge.
Mr. Estridge. Cause number CR 11-119, State versus Jeremy Wayne Estridge for status on restitution compliance. Go ahead, Mr. Schmidt.
Judge, we're gonna ask to continue him on restitution status. I think we made a lump sum payment of, what did you say, 1,200? 1,300. 1,300 since we were here last. We'd ask for a 60-day reset.
Any objection from the state on a 60-day reset?
No, Your Honor.
All right, we've got about January 21st.
Yes, sir.
All right, court sets Mr. Estridge for restitution compliance status on January 21st, 2025 at 9 a.m.
Mando Hernandez.
Mr. Hernandez. This is cause number CR 23-162, State versus Fernando David Hernandez for a docket call. Go ahead, Mr.
Judge, I'm still working with the state, ask for additional docket call setting.
Any objection?
No, Your Honor. Thank you.
All right, there being no objection, December 17th, set for docket call at 9 a.m.
Jeremiah Holmes.
Mr. Holmes. cause number CR 24-141, State versus Jeremiah Garen Holmes for docket call. Go ahead, Mr. Schmidt.
Judge, we're gonna ask for additional docket call setting for at 12:17.
Any objection?
No, Your Honor, thank you.
Being no objection, final or docket call set for December 17th at 9 a.m.
Leola Jackson.
This is cause number CR 24-129, State versus Leola Autry Jackson for docket call. Go ahead, Mr. Schmidt.
Asking for an additional docket call setting on her.
Yeah, any objection from state?
No, Your Honor, thank you.
Being no objection, court sets Ms. Jackson for additional docket call December 17th at 9 a.m. Who's next, Mr. Schmidt?
We've got Braxton Johnson on the Zoom.
Cause number CR 24-166, State versus Braxton Pierre Johnson.
Hello.
All right, good morning, Mr. Johnson. Can you see and hear me okay?
Yes, sir.
All right, are you able to see your attorney, Mr. Schmidt, on your screen?
No, sir. I just see you.
Okay, you may have to move left or right on your screen to see additional people. Mr. Schmidt is in the courtroom here today. He's standing behind the podiums.
My connection very messed up too. So, but I see you. I only see you.
Okay, all right. Well, I'll let you know that we're appearing in open court today, and your attorney, Mr. Schmidt, is here. Mr. Schmidt, any announcements on Mr. Johnson's case?
Yes, sir. We're set for a pretrial. We don't have any contested motions that need a setting at this time. I ask for a docket call.
All right, there being no contested pretrial motions, court sets Mr. Johnson for a docket call December 17th at 9 a.m.
All right, thank you.
And Mr. Johnson, I showed that you're delinquent on your supervision fees, your pretrial release supervision fees, $100 towards your court-appointed attorney and $20 towards your pretrial release fee. Can you make that payment? Can you call the office and make that payment?
Yeah, I was trying to see how to make it. I was thinking maybe I was gonna bring it when I came to court, but I didn't know how to make the payment.
Well, if you'll call the Van Zandt County Community Supervision and Corrections Department at 903-567-4066, then they can give you instructions on how to pay over the phone. Okay, 567-4066. Okay.
Hold on 1 second. Can you give me that again?
Yes.
What's the area code?
903-567-4066. And just let them know you need to pay your pretrial release.
467
No, 567
567.
40
I got it. 4066.
66. Yes, sir.
And let them know I'm trying to pay my fees.
Yeah, let them know you're trying to pay your pretrial release fees.
Yes, sir.
All right. We'll see you back on December 17th.
Okay. Can you have my lawyer? Can you send me an email of the court date, December 17th?
Not a problem.
Mr. Schmidt said he'll do that for you.
All right. Thank you so much.
You're welcome. Have a good day, sir.
All right.
Jeffrey Walker.
Mr. Walker, This is cause numbers CR 24-191 and 192, State versus Jeffrey Neal Walker. Pretrial. Go ahead, Mr. Schmidt.
Judge, at this time, we don't have any contested pretrial matters that need a hearing. We'd ask for the docket call on December 17th.
All right, court finding that there are no contested pretrial motions, sets docket call December 17th in each case. Mr. Walker, have you signed your conditions of pretrial release? Mr. West, you've done that? Okay, thank you, sir. Thank you.
John Schnack.
John Schnack, clause number CR 24-174. Mr. Schnack is set for pretrial.
That's correct, Judge. No contested pretrial at this time. Ask for a docket call set.
All right, there being no contested pretrials, court sets Mr. Schnack for docket call December 17th at 9 a.m. Mr. Schnack, have you paid your bond fees, your pretrial release fees?
I paid on Thursday.
You paid them on Thursday of last week. Did you pay them in full?
Yep, $60.
Yes, sir. All right, free to go. Thank you.
See you.
Who's next?
Kathy Lieja.
All right, cause number CR 24-170, State versus Kathy Layhoff for docket call.
Judge, we're gonna ask for additional docket call on 12/17.
Any objections?
No.
All right, there being no objections from the state, court sets additional docket call December 17th at 9 a.m. Ms. Escobar. All right, this is cause number CR 21-286, sanctions court hearing for Noemi Leha Escobar. All right, Ms. Escobar, I'm gonna have you come back on December 17th. And on that day, we'll talk about two things. We'll talk about releasing you from sanctions court because you've been in compliance. And we'll also talk about what we're gonna do with you expiring in January. You're still behind. So we're gonna have to come up with a plan. We may have to extend you on that day.
Okay,
Give you time, but we'll come back on 17th and we'll get it all settled that day, okay?
okay.
All right, any questions?
Do I continue doing the 22 hours?
Yes. Yeah, just let's see, just do the same thing that you did last month. 245 to probation, 425 to court, 425, and then 22 hours community service. Do the same thing.
Okay,
And we'll come back on the 17th, okay?
okay.
All right. We'll get you a notice here. Have you sign that and you'll be free to go. Jeremy Snelson here?
Pop in.
Sure. Here you go.
Robert Bradley.
Roderick Bradley, CR 24-163. Mr. Bradley, set for docket call. Go ahead, Mr. Chairman.
Judge, we're gonna ask for an additional docket call. In addition to that, I'd ask for a little bit longer time on Mr. Bradley. He's coming from Monroe, Louisiana.
Any objection from state?
No, Your Honor, thank you.
All right, there being no objection, court will set Mr. Bradley for additional docket call on January 7th at 9 a.m. Mr. Layhoff. All right, Mr. Layhaw, looks like you complied with all of your orders from the last sanctions court. You paid your probation fees, you did your community service hours. Remind me where you do your community service hours?
I'm a volunteer now.
Volunteer now. Hey, is that where you're gonna continue to do yours?
I'm
You're
completed
done?
with everything.
You're done? Okay, good. So since you've been complying and doing well, we're gonna go ahead and release you from sanctions court, all right?
Yes, sir.
So do me a favor and don't come back to sanctions court.
Yeah,
All right,
got it.
stay with your probation officer, y'all work everything out, get it all done. And it looks like you were extended, so you still have a couple of years, but I'll tell you what, if you can get all of your stuff done and if probation recommends that you be released early, I'll sign that and we'll get you off.
Sounds
Okay.
perfect. Thank you.
All right, so you don't have to come back to see me anymore, but make sure you're staying in touch with your probation officer and doing what you're supposed to do.
Got it.
All right,
Thank
free
you.
to go.
Yeah.
Tammy Crocker. All right, this is sanctions court hearing, clause number CR 05-63. All right, Miss Crocker, it looks like you paid your $90 to probation, you paid your $100 to restitution. I'm gonna have you come back on December 7th. Not December 7th, I'm sorry. I'm gonna have you come back on December 17th, just put a one. December 17th. And we're gonna do the same thing, it's $90 to probation, $100 to restitution, okay?
Yes, sir.
All right, Deputy Martinez will bring you a form, sign that, and you're free to go.
Yes, sir.
Keith Thomas. All right, Mr. Thomas, this is a sanctions court hearing, CR 21-192. All right, let's see. Last time we were in court, I gave you three things to do. Pay $120 to probation, pay $150 to court clerk, and then work 25 hours of community service. My report says that you didn't do any of those things. Is that right?
Yes, sir.
You didn't do any of them?
Yes, I did it.
What did you do? All of them?
I did all of it.
When did you pay?
I paid $60 to the probation, not 120, because it had 60 on the paper. It was 150 to the court fees and $60 to the probation. And I did 25 hours of community service. I sent it to her Friday
When on Friday?
around 1 o'clock. I had a fax paper in the car if you want me to get it for you.
I say, have a seat and let us verify all that. I'll call you back.
Okay.
Misty Backus. This is cause number CR 21-158, sanctions court hearing. All right, Ms. Backus, did you pay? My report says that you didn't pay your probation, your court collections,
I
and you didn't
paid
do, hang on,
morning.
and you didn't do your community service, and you didn't attend your monthly counseling.
I
So,
sent it to her this morning. I know it was,
sent what?
I sent my community service hours to her this morning. I know it was late, and then I paid this, the district clerk this morning. I have the receipt right here. Some things have happened. My mother-in-law has been diagnosed with brain cancer, and I haven't been able to do my community service because I've been house sitting for her because she's been gone.
Okay. So did you pay anything to probation?
No, I will after I leave here.
You're gonna pay in full today? $60 or 60?
No, all I have is
$60.
25.
How many hours community service did you do?
7.
My report also says that you owe the counselor.
Yes.
Jakes. How much do you owe him?
200. I'm not gonna be able to catch up on any of this until Todd gets out of jail in 14 days.
How do you know he's getting out of jail in 14 days?
It's whenever you look up on the TDJC site, it says the release date is the 27th.
And when he gets out, why are you gonna be able to,
Because he has a job waiting on him and he'll help me with this.
he's gonna have money as soon as he gets out of jail, or is he gonna have to work for 2 weeks?
He'll be a week late.
So why did you not do all of the community service? I understand the money, but why not the community service?
I wasn't able to leave the house because she wants me to watch her house and her dog. I know it sounds crazy, but the woman loves her dog.
This is who?
My mother-in-law, Todd's mother.
And so do you live with her?
No,
And so you just go over there to watch her house while she's gone? Instead of doing your community service?
yes, she's on her deathbed. That's one of her wishes. So I just, wanted to make her happy and not have to stress out about anything else. She's at stage 4.
I want you to put me on your wish list. I wish Misty would do what Misty is supposed to do, so I don't have to come in here and keep my thumb on her so I can keep Misty out of prison.
Okay.
I think Misty knows that
Yes.
because Judge Martin and Misty have done this for a long time. Right, so I'm gonna bring you back on December 17th. Want you to pay 65 to probation. $115 to the court collections. 24 hours community service. I want you to attend your counseling,
I do that once a month.
and I want you to pay Mr. Jakes $50.
Okay,
So you're going to have to figure out how to get that done. Misty, for each one of these that you don't do is going to be a day in jail, no questions asked.
sir.
If you come back and I say 24 hours and you said I did 7, it's a day in jail. If I say $50 to Mr. Jakes and you pay him $49, it's a day in jail.
Understand.
Okay. So you're looking at 5 days in jail for these things. If you don't do anything that I tell you, you're gonna do 5 days in jail. And then you're still gonna have to do all those
Mhm.
next month. You understand?
Yes, sir.
All right, so let me repeat that. $65 to probation, 115 to court collections, 24 hours community service, the 10 monthly counseling, pay Mr. Jakes $50. Any questions?
No, sir.
And you're gonna go pay what you said you were gonna do. You're gonna pay $25 today to probation, correct?
Yes,
Now that's for this month. That doesn't count towards the
yes.
17th. Here you go.
Thank you.
Alexa Stevens. Is Alexa Stevens here? Back on record, cause number CR 24-157, State versus Bendis Thomas Watts. Court having granted Mr. Millslagel's defense motion for continuance, the court sets Mr. Watts in for an additional docket call on December 5th at 9 a.m. Mr. Watts will bring you this notice of appearance, sign that, and you're free to go.
Thank you, Your Honor.
Mr. Burke. This is cause number CR 24-199, State versus Robert Michael Burke. Mr. Burke, you're set for arraignment today. My understanding is that you've hired attorney Kyle Rosenstein. Is that correct?
Yes, sir.
Mr. Rosenstein filed a letter of appearance. And I believe he filed a waiver of arraignment, but it was rejected by the clerk because it didn't have the correct dates in it. So what I would like for you to do is see if you could step out in the hall and call Mr. Rosenstein and see if he can just appear via Zoom. He wants to, if he's unable to be here today, if he can appear via Zoom. If so, then Mr. Abraham can give him the Zoom information that he needs so that we can get you arraigned and we can get your next court date set and get you out of here.
Yes, sir. Thank you.
Okay, just check back in. Whenever you get back in here, just let us know and we'll call you back.
Thank you.
Court calls cause number CR 15-322, State versus Keith Pryor. We're on status. Mr. Pryor is still in Polk County, Florida in custody. Does the state have any information on Mr. Pryor? And
Your Honor, let me look, take me just a couple minutes.
okay.
Your Honor, on Mr. Pryor, I do remember this is the one we needed to check to make sure that Florida was going to hold our warrant. I did reach out to Polk County, but I didn't follow up with them and I never got a response at the last setting. I had reached out to them to make sure that that was all set up. And I didn't hear back from them.
So you have some notes that say that the defendant's father called that he was set for trial in September 24th, and we got a call on October 1st that said he received a 6-month sentence on October 1st. Says he has 1 month left to serve. I don't know if he had credit for that, if he had 5 months credit maybe. And then on October 30th, note says that his father called stating that he is not in Jackson County, Florida for 60 days. So that'd be all of November, all of December. Okay. All right, court will set Mr. Keith Pryor, CR 15322. We'll set him for January 21st. Status of custody. And if you don't mind, Mr. Hartwell, see if you can get them to follow up with you, just so we'll know if our hold is on him and if they're gonna honor that.
Yes, sir.
Yes, sir. What did you find out?
He said I could give him the Zoom link.
Okay, Ms. Abraham will bring it out to you in just a minute, and then you can get that to Mr. Rosas. Thank you. Mr. White, are you ready?
Yes, and I've got Mr. McClanahan out in the hallway with new paperwork, but okay, Court, I'd like to get the rest of my.
Sure. You'd like to call first?
Let's call Mr. Lemon.
Mark Lemon, CR 15463.
We had set this for status today, Judge. The state and I have come to an agreement on this matter. And we're gonna resolve it on the 26th. For a plea. That was the day we were set. We've already got a date set on that.
Okay.
I'll let the court know, as part of this plea agreement, we're gonna be paying the balance of our financial obligations. The court, that will be paid, at least initially, I plan on paying that through my trust account with my office. Just letting the court know that, in advance. I don't anticipate us having any issues, with money that day. But if it's available, but there's some moving around that has to do. But I think we've got sufficient time to get that done by that day.
Okay, will that be a morning plea or afternoon?
It'll be a morning plea, Your Honor.
All right, court finds that Mr. Mark Lemon is set for hearing on his motion to adjudicate on November 26th at 9 a.m.
Ready to go, Your Honor.
Ready to go.
Thank you.
Oh, no, I'm sorry. Surprise needs to see him real quick.
I'll go over this.
Who's next, Mr. White?
Let's do Mr. Wynn.
Did you say Smith or
Mr. Wynn.
Wynn? Okay. To Nguyen, CR 24144. Mr. Nguyen is set for pretrial.
Yes, sir. We've come to an agreement on this matter. We'll be entering a plea. Just need a date.
I've got a couple dates in December if you want to go there, December 3rd, 5th, or 17th.
Let's do December 5th, Your Honor.
Okay. Court sets Mr. Nguyen for plea December 5th. Is that morning or afternoon?
That'll be a morning plea.
All right, at 9 a.m.
Yes, sir. Mr. Wynn, free to go, Your Honor.
Free to go.
Thank you. Delvin Mitchell, Your Honor.
Delvin Mitchell. All right, Mr. Mitchell is set for pretrial hearing. Go ahead.
Your Honor, we're going to ask the court to move this to a contested day. We've got a very limited issue motion to suppress that maybe in the queue, may not be, but Mr. Hartwell and I have discussed it. He's going to look at it as well. Probably discuss it a little more, but I would anticipate for the courts. I know you know, obviously lots of things fall through, but this would take just a real long time on your docket.
Can we be prepared on the 26th?
I've got a number of things set that day, Judge, that if we not able to come to agreements, one of them's already dropped off, so that's more of a state, because I don't know the witness availability.
We don't do it on the 26th. We're looking at the end of January.
Your Honor, I haven't checked with officers' availability, so I couldn't be 100% certain, especially with the holiday week. I don't know if there's pre-existing plans.
All right, court sets Mr. Mitchell then for evidentiary hearing on January 23rd at 9 a.m. And Mr. Mitchell, I show that you're delinquent on your supervision fees, your pretrial release. Have you paid those recently?
No, sir.
Okay, can you pay those today, $40?
Yes, sir.
All right, so once you're through here, I need you to go across to the probation pretrial release office. You know where that's at?
Yes, sir.
Just pay that before you leave town, okay?
All right.
All right, we'll see you back on January 23rd.
Mr. Williams, Your Honor.
Justin Wayne Williams, CR 20-276.
Your Honor, right now, we're gonna need to put this on the contested docket. This is a single issue motion to adjudicate dealing with the DWI that's out of county. We'd ask the court to put that on the 23rd. It's okay with the state. I think that gives them plenty of time to coordinate with Wood County.
So the state wants.
Yes, Your Honor.
All right, court sets Mr. Williams for contested hearing on January 23rd, 9 a.m.
Now, Judge, if we decide or if we're unable to come to an agreement on that, I'll try to remember for my office to email Ms. Abraham and let the court know, because that is going to probably take a little bit more time than, some of them.
Okay.
Thank you.
Mr. Smith, Your Honor.
Jeffrey Allen Smith, CR 24176. Mr. Smith set for pretrial.
Make the first part of my announcement here, and then I'm going to ask to approach, but we don't have any contested motions at this time. We'll abide by the court's standing order. And I believe you received everything. Well, there's one thing I think Mr. Crowell will still be trying to get for me, but we've discussed that.
What is that? Just so I can have it.
That there were a couple of things in regards to I believe phone records. And we had discussed that as it related to a search warrant. But we've discussed that. I don't think we're going to need those things. And if we get to the docket call, we've come to an agreement in principle on this. I'm going to explain it to the court here in a second. But if we have an issue with the availability of those things, we'll inform the court at that time.
Okay.
I don't think.
You may. All right, court sets Mr. Smith for docket call January 21st, 2025 at 9 a.m. And once he signs his notice, he's free to go. Yeah. Who's next, Mr. White?
My only remaining one, Mr. Warren, but I believe the state is gonna be.
Yes, Your Honor.
Public
State
safety.
Come on up.
And Your Honor, may I approach?
This is cause number CR 24-120, State Texas versus Jamie Taylor Warren, set for pretrial. All right, court finds that the state has filed a motion to dismiss in this cause number. And the court is granting the state's motion to dismiss. I've signed the order.
Yeah, I take that back.
Yes, court's going to attend to this to Mr. White as an officer of the court for filing with the district clerk. Mr. Warren, you're free to go.
Your Honor, Mr. McClanahan has a probation plea.
So he is here.
Yes, sir. I walked out.
Mr. Burke, come on up. Mr. Rosenstein, good morning, sir. Can you see and hear me okay?
Yes, Your Honor.
All right, this is cause number CR 24-199, State of Texas versus Robert Michael Burke. Court finds that Mr. Burke is represented by counsel, Mr. Kyle Rosenstein. We're set for arraignment today. Mr. Rosenstein, I understand that you did file a waiver of arraignment. However, I believe it was rejected because the dates were not correct. I think it had the pretrial date being today, so there would not have been another reset date. So have you gone over the indictment with your client?
Yes, Your Honor.
All right, and does he understand what he's charged with?
He does, Your Honor.
Does he waive the formal reading of the indictment?
He does, Your Honor.
All right, and how does he enter a plea?
Not guilty, Your Honor.
All right, court finds that Mr. Berg, represented by counsel, has waived the formal requirements of arraignment. The court does enter his plea of not guilty into the record, and the court sets Mr. Berg for pretrial hearing. Do you have your calendar with you, Mr. Rosenstein?
Yes, I do, Your Honor.
All right, I've got a few dates in December. Got December 5th or December 17th.
December 17th, Your Honor.
17th. All right, Mr. Berg, court sets you for pretrial hearing December 17th. That will be at 9 a.m. and that'll be in person. And Mr. Rosenstein, any pretrial motions that need some kind of evidentiary hearing need to be filed 7 days prior to that date with notice to the state. And
I understand.
if you do file a motion, then it will not be heard that day, but we'll set it that day. Okay.
Okay, thank you, Your Honor.
All right, and make sure that if you haven't already gotten in contact with the DA's office, that you've contacted them and signed up for their online e-portal discovery.
Will do, Your Honor.
Okay, all right, Mr. Burke, you're free to go.
Thank you, sir.
Thank you, Mr. Rosenstein.
Thank you, Your Honor. May I be excused?
Yes, free to go.
Thank you.
Mr. Watson. Where's your attorney at? From where? When did he, how long ago was that? Say that again.
I guess like 5 minutes ago.
He says he's on his way from Tyler? Okay,
Sir.
thank you.
Yes.
Thank you. All right, court is going to stand in recess until Mr. Schmidt is ready, or Mr. Platt appears, or Mr. White is ready. So I'm gonna give the attorneys time to work with their clients. So course recess for at least 20 minutes. It's 10:20, so y'all can all check back in about 10:40, okay? Court's in recess. White, you ready? Yes, sir. Who would you like to call up first?
Just got Mr. McClanahan, but
Who did you say?
Mr. McClanahan, Your Honor.
Before we go through with this, where does Mr. McClanahan live?
Great, great.
All right, this is cause number CR 23-109, CR 23-110, State of Texas versus Brandon Dwayne McClanahan. Mr. McClanahan, sir, if you'll raise your right hand, I'm gonna place you on oath. You swear that the testimony you give to the court today with the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, you can lower your hand. Your name is Brandon McClanahan, is that correct?
Yes, sir.
Mr. McClanahan, are you a United States citizen who reads, writes, and speaks English?
Yes.
And in this case, you are represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White and the services that he's given?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No.
And do you have any questions about your plea agreement and recommendation before we go further?
No.
Mr. White, do you believe Mr. McClanahan to be competent?
Your Honor, I believe Mr. McClanahan to be competent, that he understands the proceedings that are pending against him here today. In front of the court, we have some written waivers and admonishments. He's executed those waivers and admonishments knowingly, intelligently, and voluntarily.
Thank you, Mr. White. All right, Mr. McClanahan, in cause number CR 23-109, you are charged by indictment. Is that correct? With a Class A misdemeanor, or was the original case something higher?
I believe it was by indictment that we proceeded on that one. Both of them were by indictment.
Both by, so the Class A indictment?
Yes.
All right, in cause number CR 23-109, Mr. McClanahan, you are charged with a Class A misdemeanor offense of taking wildlife resources without consent. That does have a range of punishment of not more than 365 days in the county jail and a possible fine not to exceed $4,000. I see that plea agreement in that case is upon your plea of guilty, the DA's office is recommending that the court consider the evidence and then follow the plea agreement and assess punishment at 1 year confinement in the county jail. They're asking the court to suspend that sentence and place you on community supervision or probation for 2 years, along with a $1,000 fine plus court costs and reimbursement fees. In cause number CR 23-110, you are charged by indictment with a third-degree felony offense of unlawful possession of a firearm by a felon. That does carry a range of punishment of not less than 2 years or more than 10 years in prison and a fine, if imposed, not to exceed $10,000. The plea agreement and recommendation from the DA's office is that the court consider the evidence, assess your punishment at to convict you of the offense, and then assess your punishment at 10 years confinement in prison. But the DA's office is asking that sentence be suspended and you be placed on probation for a period of 5 years, along with a $1,000 fine plus court costs and reimbursement fees. And the DA's office is also indicating that they will ask the court to dismiss a cause number CR. Let me fix that again. DA 2022-1431, a criminal trespass, and DA 2022-1438, a tampering or fabricating with physical evidence. They're asking that this sentence run concurrent with your sentence in the other case, the Class A misdemeanor. And also, I guess, as a term of the agreement, there is no early termination of probation, and that there will be a weapon forfeiture in that case. Is that your understanding of the plea agreement, Mr. McClanahan?
Yes, sir.
Any questions about any of those things?
No, sir.
And Mr. White, is that the agreement between the defense and the state?
Yes, sir.
And so, just so I'm clear, that he's agreeing to not request early termination in cause number CR 23-110, firearm by felon.
That is correct.
Okay. All right, Mr. McClanahan, understanding the charges, understanding the range of punishment, understanding the plea agreement. I'll ask you at this time, how do you plead to taking wildlife resources without consent? How do you plead to unlawful possession of a firearm by a felon?
Guilty.
Are you pleading guilty to each one of those crimes because you are guilty of committing each crime?
Yes,
Has anybody threatened, forced, or pressured you to plead guilty?
no, sir.
All right, then the court does accept the defendant's plea of guilt at this time. Mr. White, any objection to the stipulation of evidence in each case?
We have no objection.
All right, stipulation of evidence is admitted in each case respectively, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, the court will consider the evidence. All right, the court, having considered the evidence, finds that there is sufficient evidence to convict the defendant in each case. Court will follow the plea agreement and the recommendation of the DA's office. Cause number CR 23-109. The court convicts Brandon Dwayne McClanahan of taking wildlife resources without consent, a Class A misdemeanor. Assesses punishment at 1 year confinement in the county jail. Court suspends that sentence, places him on 2 years community supervision, orders him to pay a $1,000 fine, $270 court cost, and $35 in reimbursement fees. Cause number CR 23-110. Upon considering the evidence, the court finds Brandon Dwayne McClanahan guilty of unlawful possession of a firearm by a felon, a third-degree felony. Assesses his punishment at 10 years confinement in prison. Court suspends that sentence, places Mr. McClanahan on 5 years community supervision, orders him to pay a $1,000 fine. Court orders that the sentence in this cause run concurrent with CR 23-109. The court finds that the agreement is no early termination of community supervision in this matter. Court also dismisses under section 1245 2 unfiled cases, criminal trespass and tampering, fabricating with physical evidence. The court orders the forfeiture of the weapon seized in this matter as outlined in the judgment. Court orders him to pay $290 court costs and $35 in reimbursement fees. All right, Mr. McClanahan, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted with Deputy Martinez. After that, you will meet with the probation department and give you more information.
Your Honor, that's all I have.
Yes, thank you, Mr. White. Do you have anything this afternoon?
No, sir.
All right, enjoy your day, sir.
Yeah.
Mr. Snelson. All right, this is sanctions court hearing. Clause number CR 23-120. Mr. Snelson, called your case at 9 a.m. Where were you at?
I was 10 minutes late, sir.
You were 10 minutes late. I was sat in here for hours before I took.
I know I came in right after you called my name.
Plan today was to let you out of sanctions court.
Yes, sir.
That 10 minutes is going to cost you another 30 days.
Okay.
So I'll see you back on December 17th. Everything that you did last month, I want you to show up on the 17th and we'll talk about it again.
Yes, sir.
And court starts at 9. Okay.
How's that?
I'll be here. Here, let's get you a notice of setting. This puts 12/17. Price. This is a sanctions court hearing. Clause number CR 21-88. All right, Ms. Price, I have got confirmation that you have paid your court costs and your probation fees. I'm going to reset you for December 17th. What I do show that you did not comply with was providing the information to the probation department regarding your reason for missing the June court date.
I will have that too by next court, sir.
I want that on December 17th, but because you didn't bring it today and I've been doing this for months, I'm going to order you to serve 1 day in jail for failing to comply. Okay.
Yeah.
I'm going to bring you back on 12/17. I'm going to order you to pay $60 to probation, $65 to court collections, and work 15 hours community service. For each one of those that you don't do will be 2 days in jail. So you got a potential 6 days that you're looking at for non-compliance.
Yes, sir.
Understand?
Yes, sir.
All right. Sign this notice of appearance and then you're free to go. Do you need me to repeat those, Patty? 60 for probation. And then, you need to come back here and see Miss Burns after you're done and sign for your 1 day, day in jail, okay?
Okay,
And then bring that up next court.
okay.
Mr. Platten, are you ready?
Yes, Judge. Here, I'm Dr. Watson.
All right, Mr. Watson, come on up. This is cause number CR 24-121, State versus Damon Scott Watson for pretrial. We have right there at the podium. All right. Any contested pretrial motions?
Not at this time, Your Honor.
Okay.
State and I are agreeing to possibly monitor him on pretrial for another month or so. And depending on how that looks, there might be an offer that they would want to convey to us at that point.
Okay. Well, if there's no contested pretrial motions, then I'll set it off 30 days for a docket call. And y'all can make your announcement then if y'all reach an agreement. You have your calendar with you?
I do.
I've got 12/17. You available on 12/17?
I think so.
And Your Honor, as part of the pretrial monitoring, we are asking that he be tested both today and at the next hearing for UA.
All right, so Mr. Watts, I'm ordering you to submit to your analysis test with the pretrial release officer today before you leave.
All right, yes, sir.
Also show that you're delinquent $30.
Yes, I'm going to get that paid right now.
All
So I was
right.
going that way anyway.
Okay, so when you leave court, we'll make sure you do your urinalysis before you leave, and then after that, go across and pay that $30.
All right, yes, sir. Yes, Your Honor.
Do you want this signed?
Yes, he'll need to sign, yeah, fill that out, sign it, he gets the yellow copy, white one will stay with me.
Okay, thank you, Judge.
You're welcome.
Takes the yellow, we keep one. Like goes like that. That one goes like that. Go on. Yes, sir. That was, yeah.
I'll have it reported on it. Yes, take a display. Mr. Schmidt, who are you ready on?
Sammy cocaine.
Is cocaine? This is cause number CR 24-205, State of Texas versus Tammy Renee Cocaine. Court having found Ms. Cocaine to be indigent for purposes of the Sixth Amendment has appointed the Honorable Richard Schmidt as counsel. We're set for arraignment today. Go ahead, sir.
Judge, I did receive a copy of the indictment, went over that with Ms. Cocaine. Name spelled correctly, understands the charges, waive reading and ask for a pretrial setting, enter plea not guilty.
All right, court enters Ms. Cocaine's plea of not guilty into the record, sets this matter for pretrial hearing. You want December 17th, Mr. Schmidt?
I get a little bit more time.
January 7th.
Yes, sir.
Court sets Ms. Cocaine for pretrial January 7th. 9 a.m. Ready to go.
Good here.
Thank you, sir.
Who would you like first?
Ms. Smith, aren't be fine.
Haley Smith Arndt. It's cause number CR 24-150, State of Texas versus Haley Smith Arndt. Ms. Smith Arndt, if you'll raise your right hand, place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
All right, lower your hand. Make sure you speak up loudly and clearly.
Yes, Your Honor.
All right, thank you. Lower your hand. All right, is your name Haley Smith Arndt?
Yes, sir.
And are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with a mental condition?
Yes, sir.
Can you tell me about what that is?
I've been diagnosed with severe major depressive disorder, ADHD, bipolar type 2.
Okay. Are you on medication for any of those?
No, sir.
Are you under a doctor's care or treatment for those?
I think so, sir. Yes, sir.
Are you seeing someone monthly to get any kind of medical treatment or?
No, sir.
No? Okay. Do you feel like today, Ms. Smith Arndt, that you have a rational understanding, meaning that you can understand mentally everything that's going on in this case?
Yes, sir.
You have any questions about anything before we go further?
No, sir.
You are represented by your attorney today, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work that he's done for you?
Yes, sir.
Mr. Schmidt, do you believe that Ms. Haley Smith Arndt is competent? If so, that you've explained to her the advantages and disadvantages of a deferred adjudication?
Yes, sir.
All right, Ms. Smith Arndt, you are charged by, is this an indictment?
It was an indictment, Your Honor, we're pleading to a lesser included.
Okay. You are charged by indictment with assault of a public servant, a third-degree felony. I see that the agreement and recommendation of the DA's office is to reduce that charge to a Class A misdemeanor, resisting arrest, search or transport. That does have a range of punishment of not more than 365 days or a fine more than $4,000. I see the recommendation is to consider the evidence, not convict you today of that offense, but rather to defer a finding of guilt and place you on community supervision for a period of 2 years and a fine of $50 plus court costs of $270 and reimbursement fees to Van Zandt County for $535. Ms. Smith Arndt, is that your understanding of the plea agreement?
Yes, sir.
All right. And understanding that plea agreement, understanding that range of punishment, do you understand, Ms. Smith Arndt, that if the court approves this, it places you on community supervision, also known as probation? If you're on probation, if you violate any of the conditions of probation, do you understand that the state of Texas can file a motion to convict you? They could file a motion and ask the court to revoke your probation and to send you to jail anywhere up to a maximum 365 days?
Yes, sir.
Okay. Understanding all of that, I'm going to ask you at this time, how do you plead to the Class A misdemeanor resisting arrest, search, or transport?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And Ms. Smith Arndt, has anyone threatened you, forced you, or made you plead guilty here today?
No, sir.
All right, the court will accept the defendant's plea guilty at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No, Judge.
All right, the stipulation of evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant. However, the court will follow the plea agreement and recommendation from the DA's office. The court defers a finding of guilt on the lesser included Class A misdemeanor of resisting arrest, search, or transport. Places Ms. Smith Arndt on 2 years community supervision, orders her to pay a fine of $50, court costs of $270, and reimbursement fees of $535. All right, Ms. Smith Arndt, you are hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward with the deputy to be fingerprinted. After that, the probation officers will tell you about what's next, okay? Who's next, Mr. Schmidt?
Who are we going to?
Reyes, Amanda Reyes, CR 24108. All right, are you Amanda Reyes?
Yes, sir.
Ms. Reyes, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you can lower your hand. Ms. Reyes, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any mental conditions?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work that he's done as your attorney?
Yes, sir.
Mr. Schmidt, do you believe Ms. Reyes is competent today to enter into this plea and that she understands the advantages and disadvantages of a deferred adjudication plea?
Yes.
All right, Ms. Reyes, you are charged by indictment with a third-degree felony offense of financial abuse of the elderly greater than $2,500, less than $30,000. That does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison, and a possible fine not to exceed $10,000. I do see that the plea agreement is that upon your plea of guilty, the state is recommending that the court consider the evidence, not convict you today, but place you on deferred community supervision for 5 years, along with restitution in the amount of $2,514.14, plus court costs and reimbursement fees. Ms. Reyes, is that your understanding of the plea agreement?
Yes, sir.
All right, having explained the plea agreement and the range of punishment for that offense, I would ask you at this time, how do you plead to financial abuse of the elderly greater than $2,500, less than $30,000?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
All right, then the court does accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the statement?
Nothing further, Your Honor. Thank you.
All right, victim supportive of this plea?
Your Honor, we reached out, were unable to make contact with her.
Anything further from the defense?
No, sir.
All right, court will review the evidence. All right, court, having reviewed the evidence, finds that there is enough evidence to convict the defendant. Court will follow the plea agreement and the recommendation of the DA's office. Court hereby defers the finding of guilt for financial abuse of the elderly. The court places Ms. Reyes on 5 years community supervision, orders her to pay restitution to the victim in this cause in the amount of $2,514.14, orders her to pay $290 in court costs, $535 in reimbursement fees. All right, Ms. Reyes, I suggest that you get on probation and do what you're supposed to do and not come back through here, okay?
Yes, sir.
Financial abuse of the elderly, the court is going to really give that a lot of attention if you show back up in here.
Yes, sir.
And let me remind you that you could be, and most likely would be, looking at 10 years in prison. Let that be in your mind before you make any decision.
Oh, it is.
Do what you're supposed to do. All right, if you'll come forward and be fingerprinted with the deputy, then probation will tell you about what's next. Mr. Harrison? All right, this is cause number CR 24-137, State of Texas versus J. Randall Harrison, also cause number CR 24-138. I'll need the state to sign the 1245 dismissal.
That's okay.
All right, you're J. Randall Harrison.
Yes, sir.
Mr. Harrison, if you'll raise your right hand and place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you can lower your hand. Mr. Harrison, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Schmidt. Are you pleased with him as your attorney?
Excuse me again?
Are you pleased with Mr. Schmidt as your
Yes,
attorney?
absolutely.
And do you understand everything that y'all discussed about your case?
Yes, sir.
Do you have any questions before we go further?
No.
Mr. Schmidt, do you believe Mr. Harrison to be competent? And if so, that he understands the terms and conditions of this agreement?
Yes, sir.
All right, Mr. Harrison, you are charged by indictment with possession of a controlled substance in penalty group 1 or 1B, greater than or equal to 1 grams, less than 4 grams. A third-degree felony does carry a range of punishment of not less than 2 years in prison up to a maximum 10 years in prison, and also a possible fine not to exceed $10,000. I see that the plea agreement and recommendation of the DA's office is that upon you pleading guilty, they're recommending that the court assess your punishment today at 6 years confinement in prison, but they're asking the court to suspend that sentence and allow you to stay in the community on 4 years of probation, along with a $1,000 fine plus restitution of $180 plus court costs and reimbursement fees. The DA's office is also agreeing to dismiss 4 charges, 3 of them being unindicted charges of possession of a controlled substance, tampering or fabricating physical evidence, and unauthorized use of a vehicle, and also your unlawful possession of a firearm by a felon in cause number CR 24138, along with a weapon forfeiture from that case. Mr. Harrison, is that your understanding of the agreement? Any question about any of that?
No.
All right, then understanding the range of punishment, understanding the plea agreement, how do you plead to possession of a controlled substance in penalty group 1 between 1 grams and 4 grams?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of having committed that crime?
I did. Yes.
You say, I guess?
I said I did.
You did, okay. Couldn't hear you. All right, then, Mr. Harrison, has anybody threatened you, forced you, or pressured you to plead guilty to this crime?
No, nobody did.
All right, the court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
All right, stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense? No, sir. All right, the court will review the evidence. All right, the court, having considered the evidence, finds there is evidence to convict the defendant. The court will follow the plea agreement and recommendation of the DA's office. The court hereby convicts J. Randall Harrison of the 3rd-degree felony offense of possession of a controlled substance in penalty group 1 between 1 grams and 4 grams. The court assesses his sentence today at 6 years confinement in prison. The court will suspend his sentence and place him on 4 years community supervision. Court orders him to pay a $1,000 fine, $180 restitution, $290 court costs, $535 in reimbursement fees. The court dismisses unfiled causes DA 2024-990, possession of controlled substance DA 2024-332, tampering or fabricating physical evidence DA 2024-1071, unauthorized use of a vehicle, and indicted cause CR 24138, unlawful possession of firearm by a felon. Further, the court does order the forfeiture of the weapon seized in cause number CR 24138, as indicated in the judgment. All right, Mr. Harrison, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward, be fingerprinted with the deputy, then the probation officers will tell you about what's. Yes. All right, Mr. Ellis, this is cause number CR 24-83, State of Texas versus Donald Allen Ellis. Mr. Ellis, if you'll raise your right hand, I'm gonna place you on oath. Sir, do you swear that the testimony that you give the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, Mr. Ellis, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work that he's done for you?
Yes, sir.
You understand everything that you've read and signed as part of your plea agreement?
Yes, sir.
Any questions about anything before we go further?
No, sir.
Mr. Schmidt, do you believe Mr. Ellis to be competent today? I do. And you've explained to him his rights as they pertain to this case, including the advantages and disadvantages of a deferred adjudication plea?
Yes.
All right, Mr. Ellis, you are charged by indictment with a second-degree felony offense of arson that does carry a range of punishment of not less than 2 years, up to a maximum 20 years in prison, and a fine not to exceed $10,000. In this case, the DA's office is recommending that the court consider the evidence, not convict you, but to place you on deferred adjudication for a period of 10 years. Ordering you to pay restitution in the amount of $58,826 and ordering that there is a lifetime protective order that prevents you from having close contact or communication with the victims in this case. In addition, you would be responsible for court costs and reimbursement fees. All that's been in your plea agreement. Is that your understanding and what you're asking the court to approve?
Yes, sir.
All right, understanding the plea agreement, understanding the range of punishment for this offense. Mr. Ellis, how do you plead to arson?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anybody threatened you, forced you, or pressured you to plead guilty here today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Other than to note, Your Honor, that the victim's Johnny Law is present and is in agreement with the disposition.
Thank you, Mr. Hernandez. Anything further from the defense?
No, sir.
All right, the court's going to consider the evidence. All right, the court, having considered the evidence, finds that there is enough evidence to convict Mr. Ellis of this offense. The court Hereby follows the agreement and recommendation of the DA's office. The court defers the finding of guilt for Mr. Donald Allen Ellis on the second-degree felony offense of arson, defers the finding of guilt, places him on 10 years community supervision, orders him to pay restitution in the amount of $58,826 to the victim in this case, Mr. and Miss Johnny and Arnett Law, as indicated in the judgment. Furthermore, the court orders him to pay court costs of $290 and reimbursement fees of $540. All right, Mr. Ellis, before I send you on your way, I'm going to ask you, do you feel like you're a lucky man standing here today?
Absolutely.
Tell me why do you feel like you're lucky?
Because I'm not going to jail and I got a chance to get my kids back in my life. I got a second chance at life. When I got arrested, I wasn't really good with the Bible, and then I learned a little bit and I got good with the Lord, and I just straight here forward from now on.
It's good. I'm glad to hear those things. I think another reason that you're lucky is nobody was killed.
Absolutely.
And you're not standing here today as a murderer. Very, very lucky. A lot of people that stand there in your shoes don't feel lucky. They feel like they're being held responsible for something, and it's just negative, and it's going to be hard and a long process. But they oftentimes forget how lucky they are in that they have this opportunity to not be in prison, as you said, and to be able to make up to Mr. Law and his wife what was taken from them. But we're very lucky that they were not injured or anyone else was injured or killed. So you're very lucky in that respect.
May I say apologies?
Absolutely. Go ahead.
I'm very sorry for everything that I've caused. I had a lot going on, and I regret it. If I could take it back, I would. I'm deeply sorry.
Thank you, Mr. Ellis. All right, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come up here with Deputy Martinez. He's gonna take your fingerprint. After that, you'll see these ladies and they'll tell you about what's next, okay?
Yes, sir.
Your Honor, if I may, just for clarification on the civil protection order, is that there's some documentation that was also provided to the court that was filed?
Yes, that was e-filed.
Yes, sir.
I've seen that. Have you seen that, Mr. Schmidt?
I have. We have no objection.
Okay, court will sign that in e-file. I'm holding it in my queue.
Yes.
I'll get that signed.
Thank you, sir, very much.
And then we'll serve that. I guess we'll have to serve that on him through probation or something later. Let's call cause number CR 24101, Adriana Marie Jacobs for a docket call. I'm going to reset Miss Jacobs' case and ask counsel if you can get hospital records or ER records for Miss Jacobs and provide that to the court. Court will reset Miss Jacobs for docket call on December 17th. 9 a.m. Schmidt, do you have anything? Oh, you're welcome, sir. Schmidt, please.
Thank you.
You sure anything else? All right, I believe that does include the court's morning docket. We will resume 1:30 the afternoon docket. The court is in recess till then.